Okay, Assalamualaikum warahmatullahi wabarakatuh. Okay, I'm doing some adjusting. How to adjust? Okay, all right. So this is our first recorded lecture via Zoom for our Law of Torts II, okay, Law 1511. This is to continue our lecture which we had before the MCO, okay, Movement Control Order. So we stop until occupier's liability. So the next topic is meant to cover intentional torts, okay, which is trespass, as you can see on the screen here. So we'll start. Okay, because the topic is pretty bulky, it's quite long. So I plan to divide into 3 parts, okay, of this trespass to person. Basically, let's move on. Okay, before we go to trespass to person per se, let's have a look of the meaning of the word trespass itself. Okay, since this is the first time that we discuss the topic together. Because if you still remember, in our first part of thoughts, okay, we covered or we focus on negligence, okay, thoroughly, which is you don't have to prove intention. But for part 2 of thoughts, okay, we are going to focus or concentrate on intentional thoughts. So one of them is trespass. Okay, so what is trespass? What's the meaning of the word trespass here? So legally speaking, actually, it relates to direct interference, okay, with a person's body or liberty or goods. Meaning that here there can be trespass which affect individual or person's body, physical body, or even it interferes with liberty. Liberty is more or less freedom, okay, or even interference with goods, okay, not necessarily liberty or body. Okay, all right. So when does it happen actually? At what point of time the act is considered as trespass? So it happens, okay, when a person crosses, okay, the boundary. You can see crosses the boundary of what he is allowed to. Because there are certain limitations of whatever acts that a person is allowed to commit or to do. Okay. All right, so for trespass, the topic trespass, intentional thoughts here. So basically, we are going to cover 3 parts of trespass here, or 3 kinds, okay? 3 kinds or 3 types here. First, okay, for this topic, we are going to focus on trespass to person. But even trespass to person itself, it can be further divided into 3, okay, later. And then once we are done with this part, okay, trespass to person, we are going to move to trespass to land, and then proceed with trespass to goods, actually, or interference with goods, which cover both conversion and trespass to goods. Okay, and as far as intentional thoughts are concerned, okay, the emphasis is on the word intention here. Okay, intentional thoughts in the case common law case of Letang and Cooper, 1965. So it is stated, okay, the ratio that we extract from this case is that in thoughts of trespass, okay, there must exist intention, okay, at the time the defendant does or commits his act. So if we were to compare with negligence, okay, you don't have to prove intention. Okay, there's certain elements altogether in order to prove a case of negligence. But for intentional thoughts, okay, the emphasis is on the word intention. Okay, there must exist intention. So because of that, okay, if the defendant, the tortfeasor, okay, was careless, okay, that's the word, was careless in acting as he did, okay, so the cause of action will lie in negligence and not trespass and not intentional thoughts here, meaning that here, if there's no intention on his part, so basically the suit, okay, will be based on negligence rather than intentional thought. So that's basically the 2 opposite scenario. Okay, it's either intentional thoughts or it was being committed without intention, or in other words, okay, it is committed carelessly or recklessly or negligently. Okay, we go to the elements. Okay, so this is relevant for all kinds of intentional thoughts here. So basically, for all intentional thoughts, okay, there must exist three elements. Okay, the first one, there must be a positive act, right? So meaning that here it excludes omission. Okay, there must be act on the part of the defendant, on the part of the tortfeasor. And then another element, okay, the second one is it must be a direct act of the defendant. Defendant is the one who committed the act. So number one and number two, they are interrelated. And number three, another rule, okay, governing intentional thoughts is that, okay, it is actionable per se. Okay, what's the meaning here? Meaning that here, plaintiff, okay, the claimant, does not have to prove the actual damage to his person. So it's not relevant. It doesn't matter whether plaintiff, the claimant here, suffers certain injury or damage or losses, okay, to his person. So long the act is proof is committed on the part of the tortfeasor, the defendant, yes, he can take action. Okay, his right has been infringed. So that's basically the elements, okay, for all kinds of intentional thoughts. Okay, I don't want to prolong on this. Okay, let's move specifically to trespass to person. All right, for this trespass to person, there are three categories that we are supposed to discuss. Okay, so we'll start with assault and then proceed with battery, and then the last part will be false imprisonment. But for the part one of our Zoom recorded lecture here, we'll cover on assault first, and later this part two will cover battery, part three will cover false imprisonment. Okay, so when actually a person is said to have committed trespass to person here, okay? So when a person intentionally, of course, there must exist intention, okay, intentionally causes harm at another person's body, so he is said to have committed trespass to person. But we must able to identify, okay, must be able to identify, is it assault, or is it battery, or is it false imprisonment, or can it be one act? Would it amount to all the three categories, the three types here? Okay, we'll see one by one. Okay, because we want to know how it is being proved, how it is being committed. So we focus first on assault. Okay, so what's the meaning of the word assault here? All right, because we have to know what's the definition of the term here. So basically, assault, it refers to an act of the defendant, okay, which causes the plaintiff reasonable apprehension of the infliction of battery on him by the defendant. So you can see there are two parties involved, obviously, okay, defendant and plaintiff. And then defendant did something, okay, and then it caused plaintiff reasonable apprehension of what? Of the infliction of battery. Meaning that here, battery is about to be committed. Battery is about to be inflicted on the part of the defendant towards plaintiff, right? But it doesn't amount to battery yet, okay? It is still an assault. Okay, from this definition, actually, we are able to extract the elements, okay? So we have three elements of assault, and all the three elements must be fulfilled. Okay, the first one, okay, the first element, some gesture or preparation to commit battery. So meaning that here, it refers to mental state of the defendant, the tortfeasor, the one who commits the assault, okay, gesture or preparation. Okay, and then number two, second element, plaintiff, okay, on the part of plaintiff, plaintiff feels reasonable apprehension of immediate physical contact by the defendant. So meaning that here, it is on the part of the, from the perspective of the plaintiff. Okay, the first element on the part of the defendant. So second element on the part of the plaintiff, he fears that defendant is about to inflict injury, physical contact. Okay, all right. So one done, number two done. Okay, number three, the third element is defendant has the ability to carry out the threat. So this is how it is being assessed. How do we measure? This is actually based on objective test. Similarly here, the first part on the defendant, second one is on the plaintiff, and the third one back on the defendant. So we are going to discuss all also the relevant cases. Okay, this is the cases, landmark cases, okay, common law cases taken from common law that we are going to discuss. So at least you have 1, 2, 3, 5 cases here. We are going to discuss it all. Stephen Myers, okay, R. and Wilson, R. and Ireland, okay, Tuberville and Savage, Thomas and National Union of Mine Workers. Okay, Stephen and Myers. Okay, so this is in relation to the first element, second element. Actually, whenever assault happens, actually, by right, all the 3 elements are fulfilled. Okay, Stephen and Myers. See what happened. So it involves certain action or gestures on the part of the defendant. Okay, so basically, what the defendant did was that he threatened to hit plaintiff. Okay, all right. So in the course of doing that, okay, he advanced, okay, towards plaintiff here, with a clenched fist like this. Okay, you clench with a clenched fist. Okay, but basically before he was about to hit, okay, he was being stopped by somebody else, by a third party here. So meaning that here, there's no touching or there's no actual hitting. It doesn't amount to actual hitting here. But does it amount to an assault here? Yes, the court held that this act of the defendant here, it amounts to an assault. So if we go back to the elements, okay, so basically we are discussing the first element, gesture or preparation, okay, on the part of defendant to commit assault. Okay, in R and Ireland, okay, the issue was pertaining to words or threat, okay, through telephone, because usually it involves physical. I mean, assault is something which is physical. Okay, I mean, for example, just now, okay, here, all right. So clench fist, okay, it amounts to assault and advancing towards plaintiff, okay. But here, the issue, okay, the main discussion was that, okay, or whether words or threat through telephone would amount to an assault. So the ratio or the rule which we can extract from this case was that words which instill a reasonable fear of unlawful and immediate physical violence, yes, it amounts to an assault, even though there's nothing physical, there's no physical act on the part of the defendant. Okay, but the problem is that, okay, there was a certain debate, okay, whether words itself, okay, constitute an assault. Okay, we are still discussing the first element. Okay, it's about gesture or preparation. Okay, in the case of we have actually few cases, okay, which revolve around the debate here. For example, in 1823, okay, in the case of R and Mead and Belt here, okay, the court held that no words or singing are equivalent to an assault. So words alone, it doesn't amount to an assault. There must be certain acts, okay, which is combined with words here. But later in 1955, okay, in R and Wilson here, okay, the court took the view that to shout, okay, get out the knives, okay, would in itself be an assault without more. Meaning that here, even though there's no act on the part, there's no physical act on the part of the defendant, but when he shouted, get out the knives, okay, meaning that here it amounts to an assault, okay, it amounts to gesture or preparation to commit battery, which inflicted fear, okay, sorry, on the part of the defendant. Sorry about that. Okay, sorry about that. Okay, all right, so we were here. Okay, but now, because since we have 2 approaches here, okay, the earlier one, it doesn't amount to assault. Okay, words doesn't amount to assault, but later, words itself, okay, would amount to an assault. So the question here, the query is, okay, what's the current position or what's the better view? So more recently, all right, so we have House of Lords. view here, okay, more recently, House of Lords, HL House of Lords has stated that an assault can be committed by words alone. Right, meaning that here the House of Lords is was agreeable to the second case here, or second approach here. Okay, agreeable with R. and Wilson. Okay, but again, after some discussion, meaning that here we have some cases which which revolve around the debate here, but this is the conclusion by most of the legal jurists. Okay, but the better view is that, okay, mere words cannot constitute an assault, and there must be some gesture or preparation to inflict bodily harm. Meaning that here, in order to make your case strong, okay, so basically words, okay, must be combined with act here, okay. Right, there must be some gesture or preparation. So words alone are not really sufficient, not strong enough, okay, to prove a case of assault. Okay, and then this is the second element, okay, reasonable apprehension of harm on the part of the plaintiff. So plaintiff has some fear, okay, all right. So if there is no reasonable apprehension of an infliction of immediate battery, there is no assault. So meaning that if the plaintiff is not fearful, there's no way the plaintiff might think, okay, the defendant was about to hit him. Okay, here, all right. So, meaning that here the second element is not really fulfilled. Okay, example here, okay, illustration. To point a pistol at the plaintiff, okay, is an assault. Okay, no matter whether the pistol is loaded or not. Okay, normally, okay, when you point the pistol or whatever weapon that you have, okay, so it creates fear. Okay, it creates apprehension of infliction of battery. Okay, but okay, we have the but here. The limitation or the condition, the qualification here. If the plaintiff knows, okay, that the pistol is unloaded or empty, no bullet, okay, so there is no assault. Why? Because there's no fear. You are not going to shoot me after all. Okay, the pistol is unloaded. All right. So it depends very much on the part of the plaintiff. Okay, the feeling of the plaintiff, whether there was reasonable apprehension on his part or not. Okay, the actual feeling of the plaintiff. Okay, the third element, okay, ability to carry out the threat. So, okay, here, all right. Again, it goes back to plaintiff, right? If the plaintiff knows that the defendant has no present ability to carry out the threat, there is no assault, even if the threat is intimidating or even frightening. So, again, we look at the perspective of the plaintiff, whether he knows whether defendant can actually carry out whatever that he said, whatever that he threatened. So gesture alone can constitute an assault. For example, raising one's fist in other's face, okay, clenched fist here. But words may also reinforce an action or vice versa. It may negate the intention. Okay, for example, I'm going to hit you. Or maybe if you do this, actually it negates your intention. It's possible, okay, from the decided cases. Okay, so meaning that here, on the other hand, okay, words may signify, may indicate that defendant has no intention of carrying out any threat. And because of that, okay, in such a situation, plaintiff will not be able to establish, to prove that there was a reasonable apprehension of unlawful force here. Okay, let's have a look at the case. We have the cases. Okay, the case is Tuberville and Savage. Very, very old case, classic case here. He said that, all right, if it were not a size time, okay, I will not take such language from you. Okay, actually, this is conditional threat because it is stated here if. Okay, here, if, right? So basically, he wouldn't do that. Okay, right, let's have a look what happened actually here. Plaintiff put his hand upon his sword. In the here, he put the hand upon his sword, and he was holding the sword, okay, and he said, if it were not a size time, okay, I will not take such language from you. Okay, what is a size time here? A size time in here, it's a trial session, civil or criminal, held periodically, okay, those days, okay, in specific locations in England, usually by a judge or a superior court. Okay, meaning that here, when he said so, actually, it was a size time. Okay, all right. So as it was a size time, the court held that these words, okay, negative the elements of intention, okay, on defendant's part to carry out the threat, and therefore assault was not established. Okay, alright, because there was if here. Okay, so it doesn't amount to assault. It negates his intention to do the threat. Okay, to carry out the threat. Okay, another case to illustrate the third element here, Thomas and National Union of Mine Workers. Okay, so it involves certain miners here. Okay, miners who went on a picket, a demo here, right? Threatened other miners. Okay, they yelling threats. Okay, the threat here, who did not join them in the picket. So there were two groups. Okay, one joining the picket, another one not joining the picket. And then the police was there to observe and to ensure things does not go out of control. So there was police, okay, right, when they held the picket here, the demo here. So the court held that, okay, the threatening yells, okay, made by the miners who were on picket, okay, did not amount to an assault. Why? Because the plaintiff knew, okay, on the part of plaintiff here, the plaintiff knew as a reasonable man that these threats could not be carried out there and then, okay, because why? There was a police there, okay, and I think they were on board of certain bus, okay, if you read other reports. Okay, so that's basically our lecture discussion on the part of assault. Okay, so the second part will cover battery, and then hopefully you are able to compare, okay, between assault and battery, the connection between the two tortious actions here. Okay, until then, we'll stop here. So we'll see you in the second part of our trespass to person. Assalamualaikum warahmatullahi wabarakatuh.